what do you call it when someone profits off your labor, controls your mobility, restricts your pay, and silences your voice, all while claiming you should be grateful for the opportunity? You call it legalized theft. Welcome back to the BWISE PoliSports podcast mini-series, Legalized Theft, where we pull back the curtain on economic, racial, and political systems that has systematically devalued black women in sport. I'm your host, Political Lil, and in episode 1, we laid the foundation, 27 years of racialized and gendered economic exploitation in the WNBA. We asked the tough question, what does justice look like when the system was built to legally exclude you from wealth? Today in episode 2, we take that conversation further into the courtroom, the Constitution, and the contracts. This episode is called Legal Frameworks for Reparative Justice in Women's Sports. Because here's the truth, if it's not criminal, it's unconstitutional. From unpaid college labor to restricted salaries in the pros, from brand neglect to institutional underpayment. The theft may be legal, but that doesn't make it just, and it certainly doesn't make it unchallengeable. We'll break down the legal architect that enables this exploitation, and we'll name names. 13th Amendment violations through unpaid labor and the theft of black women's likeness. Antitrust violations, hiding behind salary caps, forced draft and franchise control. The failures of Title X to protect black women in sports. And how civil rights and labor law were never truly written with us in mind. We'll also spotlight athletes in lawsuits, from the NCAA to the NFL to Olympic courts, that show us what legal resistance looks like. And finally, we'll reimagine what sports reparation could mean as a pathway to economic justice. This isn't about charity, it's about restitution. This isn't about equality, it's about repair. So stay with me, because today we're laying down a legal case for justice in women's sports. Let's get into it. Let's start where we often don't, with the law. Because on paper, the law should protect you. On paper, you shouldn't be exploited, underpaid, or erased. But what the law says and what the sports industry does is totally two different things. First up, the 13th Amendment. Now, most folks only know the 13th Amendment as the one that abolished slavery. But let's break that down. The amendment clearly states, neither slavery nor involuntary servitude shall exist within the United States, except as punishment for crime. What does that mean in sports? It means you're not supposed to be working without pay, especially if your labor generates profit. But for decades, college athletes, especially black women, were underpaid while their names, image, and likeness were used to sell everything from jerseys to ticket sales to TV deals. And let's be clear, this wasn't just about men's football or basketball. Women athletes, track stars, gymnastics, hoopers were part of this machine. They just didn't get the headlines or the checks. Pre-2021, athletes were banned from profiting off their own identity. But the NCAA and its corporate partners, they made billions. That's a form of legalized labor extraction, and it walks dangerously close to the line the 13th Amendment was meant to protect against. And even today in professional leagues like the WNBA, we see echoes of this. Players underpaid despite being the product, forced to play year-round overseas just to make a livable income, or worse, locked into contracts that control their mobility even when pregnant, injured, or devalued. Now let's talk civil rights law, specifically Title VII. This law bans discrimination in employment based on race, color, sex, religion, or national origin. Sounds good, right? But what happens when discrimination isn't just individualized, it's structured? Let's talk numbers. The average white woman athlete receives 4 to 6 times more in NIL deals than a black woman. Black WNBA players are underrepresented in major sponsorships, even when they're leading in performance and visibility. Media coverage. You already know. Black women get less coverage, and when they do, it's often framed through negative tropes, too aggressive, angry, emotional, ungrateful. That's Title VII discrimination in action. Not always in the form of slurs or hiring bias, but in how economic value is distributed, who gets to be the face of the league, and who gets erased in the branding process. Now let's move to labor law. Collective bargaining is supposed to level the playing field. It's meant to give workers the power to negotiate for better wages, safety, and protection. But in the WNBA PA, the players' union has historically been forced to negotiate with limited power. Why? Because the NBA controls the league. That's like a tenant negotiating rent with the landlord's parent company. It's a conflict of interest baked into the system. And let's be real, past CBA deals lock players into low wages with few benefits. Even as league profits grew, players were often asked to sacrifice for the growth of the game. WNBA wins like maternity benefits and higher minimum salaries are recent and came only after public pressure and near strikes. So yes, the law technically protects the right to organize, but power imbalance makes that protection feel symbolic, not structural. Now here's how we connect the dots. The exploitation of women's sports mirrors other labor systems we've already called out. It's like the gig economy, where you do the work, but someone else owns the platform and reaps the rewards. It's like an unpaid internship, where the promise of exposure replaces a paycheck. And it's like prison labor loophole, where the labor is legal, but the power dynamics are oppressive. This is not just sports. It's a blueprint for systemic exploitation, and black women are always asked to bear the weight. So when people ask why we're talking about reparations in sports, why we're calling out this series, Legalized Theft, why we say if it's not criminal, it's unconstitutional, it's because the law has been weaponized to look the other way, to excuse labor violations, racial pay gaps, and brand erasure, all while praising progress. But we're not here for symbolism, we're here for justice, and that means naming the laws, exposing the contradictions, and building a case for reparations. When people think of Title X, they think progress. They think of trailblazers, the milestones, the equal opportunities. And yes, Title X was a landmark law. Passed in 1972, it declared, no person in the United States shall on the basis of sex be excluded from participation in any education program or activity receiving federal financial assistance. It changed the game. Schools had to start investing in girls and women athletics. Colleges expanded sports rosters. Scholarships opened doors that might have been locked tight. But here's the question we're asking today. Progress for whom? Because when we zoom in, when we desegregate by race, a different picture starts to emerge. Let's talk implementation. Title X was never built with race in mind. Its language protects the text on the basis of sex, not intersectionality. So while white women in suburban-dominated sports like soccer, swimming, and lacrosse saw massive gains, black women were left out, marginalized, and pushed to under-resourced programs. Even within basketball, a sport dominated by black women on the court, we're underrepresented everywhere else. Only 15% of head coaches in women's college basketball are black women, despite the fact that black women make up the majority of players at the elite Division I level. In administrative leadership, even worse. Less than 5% of athletic directors are black women. And in the NIL era, while white women athletes, particularly in volleyball, gymnastics, and softball, rake in deals from brands like Gatorade, Nike, and Lululemon, black women athletes are often overlooked, underpaid, or cast as one-dimensional characters, aggressive, loud, angry, too urban to be the brand face. That's not a gap in talent, that's a failure in policy, enforcement, and cultural imagination. And here's the deeper issue. Title X has no racial equity mandate. There's no mechanism requiring schools to ensure that race and gender equity intersect, which means a school can technically be compliant and still leave its black female athletes in underfunded programs without adequate coaching, medical care, or exposure. And let's be honest, when black women report Title X violations, they are less likely to be believed, less likely to be protected, more likely to face retaliation, isolation, and even career derailment. That's systemic and it's legal neglect. So where's the legal accountability? It's almost non-existent. Federal enforcement of Title X often relies on complaints, not proactive investigation. That puts the burden on the athlete, not the institution. And when schools are investigated, they get slapped on the wrist, a chance to self-correct, and millions still flowing in from boosters, TV contracts, and alumni donors. It's the kind of selective accountability we've seen in policing, housing, education, and now sports. Title X was never built for black women. We were an afterthought, and the numbers reflect that. The question now is whether the law will evolve to serve those it has historically excluded. Now let's call it what it is. Title X compliance without racial equity is performance, not progress. If we don't demand intersectional accountability, we're not reforming the system. We're repackaging exclusion in feminist language. Because it's not enough to say more women in sports. We need to ask which women, who benefits, and who is still being left behind. Next up, we're going to pull back the curtain on a law that was never designed with athletes in mind, but holds massive power over their lives and earnings. It's time to talk antitrust law and why forced drafts, salary caps, and controlled labor markets aren't just bad policy. They might be illegal. Stay with me. Let's talk antitrust law. Now, I know it might sound like something that only applies to Amazon or Apple or Google, but antitrust law, and specifically the Sherman Antitrust Act, is not just for tech bros in Silicon Valley. It's also about sports. It's about athletes, and yes, it's about black women who've been locked into a system that looks less like competition and more like a cartel. Here's the foundation. The Sherman Antitrust Act prohibits any agreement that unreasonably restrains trade. That means no collusion, no price fixing, no backroom deals that kill competition or suppress market value. Now tell me this doesn't sound familiar. Salary caps that put an artificial limit on what players can earn, even when the league profits soar. Rookie wage scale that force elite athletes into multi-year contracts below market rate. Restricted free agency that limits players' movement unless the team gives permission. Draft systems that eliminate choice entirely. You go where you're told or you don't play. These are coordinated restraints on labor. And if that happened in tech, fashion, or finance, the Department of Justice would be knocking on the door. But in women's sports, it's business as usual. And let's call it what it is. It's legalized collusion. The WNBA, like other pro leagues, operates under the guise of collective bargaining. But when the bargaining unit is historically weak and the league is financially controlled by a larger entity, the NBA, how free is that negotiation really? Imagine if a group of Fortune 500 companies got together and agreed to cap employees' pay, lock in recruits for 3 years, and restrict their liability to switch jobs. We call that illegal. But in sports, it's called league policy. Now let's contrast that with what happens in men's leagues. The NFL was hit with a lawsuit that led to true free agency after decades of labor lock-in. Major League Baseball players sued for freedom from the reserve clause and won, opening the door to market-based salaries. Even NBA players like LeBron and Durant had forced shifts in power because they had leverage, visibility, and resources. The lesson? Antitrust only works when the players have power. And right now in the WNBA and other women's leagues, that power is still heavily suppressed. So what could be done? Class action lawsuits are a real option. And we've seen proof in recent years that athletes can win when they take it to the court. Let's look at two examples. Obama versus NCAA in 2014. The court ruled that the NCAA's restriction on athletes' compensation violated antitrust laws. Alston versus NCAA 2021. The Supreme Court unanimously ruled that the NCAA couldn't limit education-related benefits for athletes, opening the door to broader challenges. Both of these cases cracked the legal foundation of amateurism and athlete control. Now imagine what could happen if WNBA players or even college women teams challenged their labor restrictions, pay suppression, or draft mandates under antitrust law. That wouldn't be just a lawsuit, it would be a paradigm shift. See, antitrust law is supposed to protect the worker, not just the market. But when the worker is a black woman athlete, suddenly the system forgets how the law is supposed to work. And we're not going to let them forget anymore. Coming up next, we stop analyzing the problem and start dreaming up the solution. What would a legal path towards reparation actually look like? What can be done? Not just to survive this system, but to repair it. Stay with me. Okay, now that we've exposed the system for what it is, let's talk about what we can do about it. Because we're not just here to critique, we're here to build. If we agree that black women in sports, from the NCAA to the WNBA to Olympic circuits, have been systematically underpaid, undervalued, and overworked, then we have to ask, what does justice look like? What would it mean to not just fix the system, but repair the harm? Let's get into some legal routes to restitution, real paths towards reparative justice in women's sports. Number 1, civil lawsuits. First, we cannot underestimate the power of legal actions. Players can and should challenge unlawful labor practices, pay disparity rooted in race and gender, and discriminatory sponsorship or branding exclusions. Just like we saw with the Obama and Alston, civil litigation forces institutions to justify their exploitation in front of a judge, and often they can't. Imagine a class action lawsuit from black women athletes across collegiate and pro sports demanding back pay for years of unpaid NIL use, lost sponsorship potential, and discriminatory wage gaps. That's not a stretch, that's a legal strategy. Number 2, congressional action and policy reform. Change also has to come from the top. Now, Congress can expand Title X enforcement to include racial equity mandates, pass new legislation that protects athletes' labor rights, especially in women's leagues, strengthen the ability for players to unionize independently of male-dominated governing bodies like the NBA. We've seen what happened when legislation lags behind reality. NIL reform only came after decades of resistance. We can't wait that long again. We need elected officials to stop showing up for photo ops at the WNBA finals and start showing up for the policy. Number 3, a reparation framework for sports. Now this one might get some folks a little bit uncomfortable, and that's exactly why we need to talk about it. Reparation doesn't just mean a check. It means acknowledging historic exclusion and delivering economic repair proportionate to the harm done. In sports, that might look like compensation for years of unpaid college labor, investment in black women-led training pipelines, funding for programs in historically excluded communities, public funding reallocation towards women's sports infrastructure, not just men's facilities. This is about equity and repair, and the legal groundwork exists. We just haven't had the political will to apply it to women's sports. Number 4, player equity and NIL protection. Next, we need to move beyond just fair salaries. Let's talk ownership. Athletes, especially black women, need equity stakes in leagues they help build. Why should billionaires profit off the labor, image, and culture of black women while those same women retire broke or invisible? We need a new model where players co-own teams or leagues, control their NIL rights beyond college, and have a seat at the table when merch, media, and branding dollars are on the line. Number 5, community-led sports justice models. And finally, we look at those already building the future. Let's talk about Unrivaled, the player-led 3-on-3 basketball league co-founded by WNBA players Nafia Collier and Brianna Stewart. Their motto gives equity to players, limits exploitation, and shortens the season so players aren't burned out just to survive. This is what we mean by community-led justice, profit-sharing models, player cooperatives, black-owned sports venture that reinvest in the very communities the current system extracts from. It's not a dream. It's already happening. Now we need to scale it. Here's the truth. The harm is measurable. The solutions are legal. The players are ready. The only question left is, will the system move or will we move without it? In the final segment, we'll bring it all home. Not just the law, but with the legacy. Because if the law can't serve justice, then it's time to change the law. Stay with me. The conclusion is next. Before we dive into what should be done, let's take a moment to look at what has been done. Legal fights don't happen in a vacuum. They grow out of struggle. And when athletes stand up, they make it undeniable the system knows it's being watched. These aren't just policy debates, they're human stories. Resistance has always been part of sports history, and black women have always been on the front lines, whether they were named in the headlines or not. NCAA athletes and the NIL movement. The fight to secure name, image, and likeness rights didn't come from the top. It came from pressure. Pressure from players, from lawsuits like Obama versus NCAA and Alston versus NCAA. From black athletes whose jersey sales soared while their pockets stayed empty. Today's NIL deals are a result of years of unpaid labor and legal activism. But we still see disparities. The biggest deals go to white athletes in top-tier programs. NIL isn't equity until it works for everyone. Olympic athletes like Allison Felix. Let's talk about Allison Felix, one of the most decorated track stars in history. When Nike told her that pregnancy would jeopardize her endorsement, she said no and walked away. Her stand sparked public outrage and forced Nike to adopt new maternity policies. That's what resistance looks like. That's what shifting culture looks like. It wasn't just about her, it was about every athlete who might want to be a mother and a champion. The NIL lawsuit like Brian Flores versus the league. When Brian Flores sued the NFL for racial discrimination and hiring practices, it peeled back the curtain on what we already knew. The system is rigged. His lawsuit is a template. It shows how legal pressure can expose collusion, racism, and bad faith in hiring practices. And while this was in men's football, the same playbook applies to women's sport, where black women are more underrepresented in coaching, front office, and media roles. WNBA are players opting out of the CBA, and of course the WNBA. These women said enough was enough. They opted out of their collective bargaining agreement. They refused crumbs. Players like Nneka Ogwumike and now rising leaders like Nafisa Collier are rewriting the rules. They're not just asking for better wages, they're demanding ownership, equity, and dignity. That's why we now have Unrivaled, a players-owned pro league that was launched outside of the NBA's control. That's why we're seeing players with multi-million-dollar name, image, and likeness deals even before they go pro. These case studies matter because they prove one thing. Change doesn't happen until someone disrupts the game. Resistance is legal strategy, it's economic leverage, it's cultural power, and it's our blueprint going forward. Let's not sugarcoat it. What we've exposed today isn't just an oversight or a set of unfortunate coincidences. What's happening to black women in sports is systemic theft, and it's not being prosecuted as criminal, then it damn sure needs to be challenged as unconstitutional. Because when black girls are locked out of opportunity, when black women are erased from NIL payouts, when they're sidelined from leadership, ignored in Title X and underpaid at every level, that's not just injustice, that's legal failure. That's America failing to uphold its own laws when black women are the ones asking for them to work. There's a wide canyon between what's legal and what's just. And black women are always expected to survive that gap. But as we've seen today, we have tools: legal pressure, collective organizing, public policy that centers racial equity, and media storytelling that refuses to be erased. We're not waiting for permission. We are exerting power in courtrooms, boardrooms, and locker rooms. Coming up next in episode 3, we're going to talk about the business of exploitation. We're going deep into the economics. But it's not just about who's underpaid, it's about who profits from that exploitation. From college sports to corporate endorsements to the entire American economic system, this model was built on the backs of unpaid labor, black labor, female labor, and we're going to break it all down. So stay with us, follow, share, repost, and tag us in your resistance. And if you're ready to organize or support this movement, head on over to respecthergame.online and download our advocacy toolkit, sign a petition, and subscribe to the newsletter. We're building community, not just content. Remember, if it's not criminal, it's unconstitutional, and either way, it's time to fight. All right, y'all, if this episode moved you, don't just scroll, show up. We're building PoliSports Nation, and we need every voice in this fight. Here's how you can take action right now. Like, comment, subscribe, and share this episode with your network on IG, Threads, YouTube, TikTok, wherever you build your people power. Visit respecthergame.online and get plugged in. Sign the petition calling for the WNBA labor protections and NIL reforms that include and protect black women. Download the Respect Her Game campaign toolkit. It's ready for athletes, fans, teachers, parents, coaches, and community organizers. That's your playbook for resistance. And if you're a legal scholar, athlete, coach, or cultural worker, and this episode hit home, we're looking for panelists and contributors. Come share your voice. This is a community-led media project, and your perspectives matter. Now let's turn these conversations into coalitions. Let's move from watching the game to changing the rules. Because when you stand with black women in sports, you stand on the side of justice, truth, and the future generations who will not play by exploitative rules. Join us at PoliSports Nation. Join us at Respect Our Game. Join the resistance. And remember, sports is never just about the games we play, but the stories we tell and the systems of power in sports that we expose. This is a battle for the soul of a league built with black labor, and it's time we create wealth from the fruits of that labor. This has been Political Lil for BWISE PoliSports Podcast, where we don't just watch the games, we change it. Remember, silence has never protected us. We either mobilize or keep watching our black players be monetized. Stay tuned, talk soon, and we out.